Hi, everybody. We're going to start in a little bit. If you should be hearing my voice. If you're not hearing my voice, then there's something wrong with your audio settings, and you should just mention something in the chat, and Liz will help you.
Oh, hi. I just got in. Hello?
Oh, hi, Grant.
Yeah, I'm live. Okay, I finally got in.
Oh, good. Your volume is a bit low.
Just need to activate your webcam.
Yeah. So go here. Here my webcam.
Bingo. There we go.
Okay, great. So we'll get started. Good evening, cooperators, and thank you for joining the CHFBC team for another virtual member education event. I'm Michelle Iverson, the Chief Operating Officer for CHFBC, Coho Management Services Society, and the Community Land Trust. And it's my pleasure to welcome you to tonight's event. There are few places that someone before us has not called home. On our journey to truth and reconciliation, it is our custom at CHFBC to acknowledge that the land that which we work and study and live in this province is home to 198 distinct First Nations. Since this session is being held online, a singular land acknowledgement does not capture the richness of these traditional and largely unceded territories. So wherever you are tonight, I invite you to commit to the kind of thought and action that will lead to meaningful reconciliation with the original stewards of the land. Like the rest of the world, CHFBC has gone virtual. Our planning and renewal programs are still working with co-ops. Our group buying program has been modified, and we have a great lineup of education events. The response has been incredible because we're reaching more members than ever before. Last month, we had our COVID-19 town hall, and we had more than 150 members attend. And this was a new record for the attendance at a CHFBC event. So tonight is our always popular Ask the Lawyers. And you'll recognize Jeffrey Dabbs from Galen Dabbs and Grant Haddock from Grant Haddock and Company. Tom Armstrong, CEO of CHFBC, Coho, and the Community Land Trust will be moderating tonight's event. And behind the scenes is Debbie Van Kuyk, Education and Events Coordinator and our resident webinar expert, and Liz McDonald. She will be manning the chat box tonight and also assisting you in case you have any technical difficulties. Before I turn it over to Tom, just a few housekeeping items. So this is a look at your webinar control panel. You notice that you've been muted to avoid any background noises, and you've already sent in your questions, but you can use the chat box to engage with each other or to ask for clarification during the webinar. If your question is for the panel and it's a new question, we can't guarantee that we're going to be able to get to it tonight, but we will respond by the end of the week. And if you're participating by phone, you'll be in listen only. So if you need a clarification, then Liz has put her phone number in the chat box. We are going to be using polls tonight. So I wanted to try out a poll in just a little bit. But first, let's take a look at we have a combination of video, which you can see the panelists, and you can also see the presentation slides. So this shows that you can grab it up and down to adjust how much of the panelists you see and how much of the slide that you see. So I'm going to launch a poll right now. Leave it open for a minute so you can try it out. We have had some people that have been unable to vote, so let us know if it works for you or not. So the first poll is launched. And we encourage you to vote. We're going to leave it open for a little bit. Okay, so I'm closing the poll. This was just 53% of you voted, and
all right.
surprise.
Oh yeah. Whoa.
So
Okay, I'm
that's
gonna
always
stay.
good news. And actually,
stay
that
on.
is the correct answer, especially for tonight. So I am going to pass it over to Tom now.
Thanks, Michelle. And I did want to start on that kind of positive note, because you might have expected me to begin with some cheap lawyer joke, but instead I wanted to show that of that group in the Canadian population, lawyers are actually trusted the most, and get us off on that that positive start. I want to thank our great team behind the scenes again, Debbie and Liz and Michelle up front. This is a lot of work to put one of these events together. The easiest thing to do in a format like this is to sit here and ask the questions. So I pulled the easy straw for the evening. I'm very, very happy that everyone could join us. We have more than 125 people online at the moment. So it'll be a little different. Some of you may have been used to the education conferences that feature the Ask the Lawyers session, and you know it's quite interactive. We're a little bit constrained because of the number of people we have and because it is a virtual environment. So we're going to be using those polls to try and draw you into the process. But for the most part, we'll be rolling through the questions that you submitted in advance. And did you ever submit questions? We have 39 questions from, and in fact, we had more than that, but we've consolidated a few. So I hope you'll forgive me for taking some license with the questions you sent in so that I could get them to fit on one slide. But they're organized in the categories that you see in front of you. So we'll move through questions around governance. You had lots of questions about how to hold meetings during the course of a pandemic. You have lots of questions around how to interpret the co-op's rules and policies in this very uncertain time. And of course, you have questions about the extent to which the usual procedures around membership terminations do or don't work in this time. Most of the questions you submitted were specific to COVID-19 or the pandemic. But there are also some general questions that we'll try to get to as time permits. You had financial questions. You had questions that deal with the operations and maintenance of your co-op. And there are a few miscellaneous questions that we'll wrap up with at the end. So that's the way we're going to proceed is that we'll show the questions one at a time on the screen. I'll read them out, and then either Grant or Jeffrey will tackle them, and then there may be a little bit of an exchange. If we're lucky, we may even see a disagreement or two between the lawyers. That's always something to look forward to. So Michelle, why don't you move us on to question number one, and we'll get the proceedings underway. So this is about, again, governance, meetings. Are co-ops legally able to hold board meetings and members meetings using online platforms like Zoom or Skype? Over to the panel.
Okay, rock, paper, scissors to go first.
Virtual, yeah, virtual. Okay.
Okay, virtual.
1, 2, 3. Oh, you got it. Alrighty.
Okay, I got it. Okay, good evening, everyone. I thought that poll was interesting because it wouldn't allow me to vote, and I was trying to vote. So the poll about who you trust the most was a lawyer in the background trying to pump up the vote. But what the heck? So the question is, are co-ops legally able to hold board meetings and members meetings using online platforms like Zoom and Skype? Yes, indeed. Subject to what your rules say. Two ways that can happen, even apart from a recent ministerial order. Section 149 sub 1 sub B of the Cooperative Association Act says that you can do that as long as all members are able to communicate with each other. And so that could be a combination of video, most likely in the case of, if it was a general meeting, of course, a teleconference. Unless your rules provide otherwise. The model rules do not provide otherwise, so you're good. And in any event, there's a ministerial order that came out a couple of weeks ago that said, despite anything in your rules, you can do it that way. And so what the ministerial order basically did was just say the act overrules your own rules. So you're good to go on that, and especially in the case of board meetings where obviously not a lot of people.
Okay. Grant, anything to add?
Well, just one question that wasn't asked, which is how do we do our meeting? Like, how does it run? And I've got, I don't know, I must have about 16 meetings lined up for all sorts of different organizations from Stratus to nonprofits, but and they're all kind of wondering, well, how's this rodeo gonna work? Because right now we're being controlled by Michelle Iverson, and we have no choice about what's going on here, right? So, and we're able to communicate and behave and all that. But how do you make sure that the members at the meeting behave, or how do they vote? What order is there going to be? How do you make sure everyone's there? So before you embark on your Zoom or Skype meeting, I would try to write down some rules about how this meeting is going to work, and then circulate to everybody so you can at least control what's happening. Otherwise, you'll get everyone talking at once. It'll happen. Then you'll mute everyone and everyone will be angry, and you don't want that to happen either. So if everyone knows the rules before you start, it'll go a lot smoother.
Thanks, Grant and Jeffrey. The good news is that CHFBC is investing quite a bit of time and some resources in developing tips and tricks, and actually offering support for virtual meetings as a service to members. So you can expect more on that topic very shortly. Michelle, I think we're ready for question 2. So this dives a little deeper now into the question of meetings and who counts as having attended a meeting. So do members who attend a meeting online or by conference call, because we did talk about there being the possibility of a mix of the two, do they count for quorum?
This one's easy. Yes, they do. I can remember typing away a memo to a co-op client saying that your rules say that quorum is those person present, they have to be present in attendance and present in person. It says that. And I said, well, there's no way around that. And then I got an email blast from CHFBC that says, hey, there's a ministerial order just came out. And I went, oh, hooray, let's just change that opinion. The ministerial order says right in there, it's the last thing in the order, says, despite whatever your rules say, to the contrary, if you're on the Skype call or telephone or whatever, you count as a person present in person.
Super. Thank you. I think we're ready for question 3, Michelle. So now we're talking about the binding nature of votes at an online members meeting. So if you take a vote at an online meeting, whether it's by show of hands, through a video feed, or voice approval from someone who's called in, is that enough to approve a new policy or set new housing charges, if that's what the meeting was called to do?
Yeah, the answer is absolutely. It's a true vote. You'd want to have procedures. Grant's point about good procedures is there, whether it would be for people who are on video raising their hands, or others announcing their name on the phone. But as long as you are comfortable with the validity of the vote, absolutely. And you know, one of the things, this is a members meeting, so you want to make sure you also gave proper notice of the meeting and the mechanisms by which you are going to be able to attend by video or by phone. But otherwise, it's all good. It becomes a regular meeting, and it's just business as usual.
Good to go, Grant?
The only thing I'd add is that I've seen Stratas do this, but if they'll actually call out the unit numbers and say yes, no, or abstain, and then the person will actually say yes, no, or abstain. If someone asks for a secret ballot, you're hooped because you can't do a secret ballot via email or sort of video or telephone. And then we talked about, one of my clients had talked about, well, why don't we just have people like mail us in the secret ballots? We'll give them ballots beforehand. I thought, okay, that's a good idea, except I was really concerned about how how do you maintain the integrity of the ballots when they come in, and they might come in willy-nilly into where? So that could be a problem.
Good to flag that. We're presently researching some options that will deal precisely with that issue. There are some software add-ons that create the potential for elections and secret ballots. We haven't test-driven them yet, but when we do, we'll make sure that information is available to members. I think we're good for question 4. So sometimes, and in the model rules, co-ops bind themselves to hold a certain number of meetings a year in addition to the annual general meeting. So here's a question from a co-op that says, our rules oblige the board to hold a semi-annual general meeting by the end of May every year. Can this meeting be delayed during the pandemic? If so, for how long?
Yeah, this one perplexed me a bit because I haven't seen a co-op that specifically says in the rules they have to have the meeting in a particular month. So, I mean, not saying it's not possible, probably is. So the first question I would ask someone who approached me on this is said, well, show me, because it might just be urban myth. You might just think you have to have it at the end of May. So let's just be sure about that. So semi-annual general meeting, well, it sounds like one that doesn't have all the major important business that you would have at your AGM. I would think that you could delay it, and you can delay it until it's safe. You got to think about, okay, what's the downside? Our rules require it. What's the worst that could happen if you delayed it? Well, I suppose one of your members might not like that. And what can they do? Well, they might be able to go to the Civil Resolution Tribunal. But what would the Civil Resolution Tribunal say in this interesting times that we live in, which is that, well, I'm not going to make them have the meeting because it's a pandemic. It's reasonable to, in the circumstances and for public safety, people's safety, to not have that meeting. I mean, we talked about having electronic meetings. That's an option. If you want to have your SGM by the end of May, you can do it electronically.
Okay. Anything to add, Jeffrey?
Nope. That's good.
All right, I think we're ready for question 5. Oh, here's a longer one. So we've postponed our AGM, as have a number of other co-ops and other organizations, and we're not sure when restrictions will be lifted. Can the current board continue in office until the next regularly scheduled AGM in April of 2021? Or must we hold an AGM as soon as the restrictions are lifted? If an AGM must be held as soon as we're able to, what about in subsequent years? Now the rotation's off. Do we go back to holding them in April, or do we hold them a year from whenever the new AGM is scheduled?
Okay, I'll tackle that. First issue, you won't be able to just wait until the next AGM. There's a BC Registry has issued a bulletin that says, despite the rule in the Cooperative Association Act that you have to have your annual general meeting within 4 months of year end, they've given all co-ops across BC the ability to postpone that till September. And so all co-ops can postpone their AGMs till September, but you won't be able to do it longer. So they're either going to have to lift that and extend it, and they may, or you're going to have to call one. So we'll see where that goes. So right now, it's the best you can do is September. But as to the directors, the good news is the term of a director continues until the next annual general meeting. That's in 18.7 of the model rules, and then in 18.9 of the model rules, even if you're over your 2-year max, even there your term continues until there is the actual election. So you're good to go. The directors continue until the next AGM, but we'll have to sort out when that next AGM will be. And then as far as my advice goes, you should go back to your regular program schedule next year and go back to April if that's when your annual general meeting was, because of course that's 4 months after year end, and that's in compliance with the Act.
Anything to add, Grant?
Nope, sounds good to me.
Yeah, that's a question we get asked quite frequently, actually. Or a related question is the definition of year when you're calculating the term of office of a director. The directors serve for a 1-year term or a 2-year term, and the rules make it pretty clear that when we talk about a year for a director's term, we're talking about the period of time between 2 AGMs, not necessarily a calendar year the way we would normally think of a year. So that's a good clarification. Michelle, I think you have a poll for us.
I do, and just someone in the chat has said that a few problems responding to the poll. Someone has suggested to taking the viewing window out of full screen mode. So I don't know if that's going to work, but if you're having problems, let's see if that works for you now. So here's the next poll. So I'll be closing it in a little bit. Just over 50% of everyone voted, so. Okay,
Aha.
Hmm,
So
yeah.
we have an issue there. And that's good. We can clarify this. I can tell you the answer is not all of the above. But let's move on to the next question, and we'll give our panel a chance to address the issue of consent resolutions, what they are, when they're used, and how they work. So here comes question 6, which was, how can a director disagree with a proposal in a consent resolution? Over to the panel.
Oh, okay, this is my turn, right?
Yes.
Okay. Well, I guess they disagree by not agreeing to the consent resolution. So you're not forced to agree to a consent resolution. I think by definition, a consent resolution is a resolution that is consented to by all of the directors. I think that's one of the myths that's out there, is that sometimes the directors, I mean, you can have a consent resolution, and it can be done by email. And this is where I think most of the problems arise, is they, you know, say you have 7 directors and you send out an email to 7 directors and 5 respond back positively and 2 just go dark. That's not a consent resolution, because you don't have all 7 saying yes. And so that's the difference. I think that sometimes the boards will just say, well, 3 people responded and they responded positively, therefore that's a consent resolution, and it's not.
Anything else, Jeffrey?
Yeah, just if, for those of you who like references to the Act, 77 sub 3 of the Act says, unless the association rules provide otherwise, a resolution of the directors passed without a meeting, if consented to in writing by all, is a binding resolution. So there's the authority. There's nothing in the model rules that prevent that from occurring. So you just need everyone's agreement in writing. That can be email, but again, don't do the thing where there's 7 directors and you have a vote by email and 5 of 7 vote yes. That's not a meeting, and B, that's not a consent resolution, because it's only 5 of 7. So keep that in mind. It has to be a true consent for that resolution to be valid outside of a meeting.
Great. So simple question, simple answer. Just don't consent or don't sign. We have one question left in the governance meeting section. It's not a COVID-19 related question, but here we are anyway. We might as well answer it. So let's see question number 7.
Tom, just before you move on, there's somebody in the chat that's asking for a definition of what a consent resolution is and what it would be used for. Did you want to take that, or will it be addressed later?
Well, let's just a quick example. We've used them on the CHFBC board in between meetings where it's difficult for people to get together and the decision isn't particularly controversial. So, you know, in a co-op, let's use the example of a membership application. So new membership applications have to be approved by the board. Maybe that's the only decision facing the board, and there's no need to or no desire to call a meeting. If the resolution, you know, that family XYZ be accepted as a member of the co-op was circulated and received the consent by signature of 7 out of 7 directors, then that becomes a binding decision in the same way as if you had held a meeting and passed a resolution. So the consent resolution, once signed by every director, goes into the co-op's minute book in the same way that the minutes of a duly called meeting would go. Is that okay?
Thanks. Yeah, and also I think that it can be 7 sheets of paper, especially with their counterparts, right? They don't all have to sign the same sheet of paper.
If you hear the expression signed in counterpart, that means that you might have 7 copies of the resolution. As long as each one of them bears the signature of a director, you're good to go.
Okay, so I'm just going to go on to number 7 then, Tom.
One more question in this general meeting section. Under the co-op rules, can the chair of a meeting vote? And further to that, can the chair vote to break a tie?
Okay, that's over to me. This question comes up because historically, and I think it's in trade unions and a lot of other organizations, they have a lot of rules about that kind of thing, where the chair sometimes can't vote, but then if there's a tie, they can break the tie. So none of that is the case here, in the sense that it's crystal clear both for meetings of members at under 15.2A and meetings of directors under 19.7A. The chair does get a vote, and they do not get a second or casting vote. And again, I've never seen a housing co-op that didn't follow that rule. And I've seen a lot of situations where people think the chair can't vote. And it's again, it must be a historical thing outside of the housing cooperative sector. So the chair can vote and the chair cannot cast a second vote.
I thought it was an option at one time. I think Rules 1.0 was an option.
Okay.
And
okay.
it might even be, it might still be in Rules 2.0 as an option, but I've always recommended against it because it seems pretty undemocratic, really.
Right.
And if also it can be really uncomfortable if you're the chair and you're the one making an unpopular decision, at least half people don't like. So you don't want to be the lightning rod for dissension. So I've said, it's not really a good idea. It doesn't seem very democratic.
Yeah, I've actually never seen someone adopt it, but it very well, again, it's subject to your rules. All of this is subject to your rules.
Yeah, that's the main point. People often ask us, well, how do you break a tie, or what happens in the event of a tie? And on a model where the chair doesn't get that casting vote, a tie resolution fails. On the theory that if something is going to pass, you should be able to get at least a majority of the people casting a vote to agree to it. And if they don't, if it's a tie, then the motion fails by default. So that takes us through the section on meetings. But don't worry, we have a ton of questions. Still on the general topic of governance, but to do more with rules and policies of the co-op, beginning with some of the COVID-related questions. But Michelle, I think you also have another poll for us to set this section up.
Yes, I do. And the issue of the not going in full screen seems to be working. So that's good news.
Ah, good.
Thank you for that. I think it was Maria. I'm going to be closing it in 3 seconds. A lot more people voting. The voting rate has gone up to 65%. So I'm closing it at 67%, and I'll share the results.
Brilliant.
There's smart people out there.
That is the right answer.
Mm-hmm.
All right, let's see the first question in the rules and policy section. So here's a big ticket item. And this hadn't occurred to me until the question came in. So thanks to whoever submitted this question. If we have an outbreak of COVID-19 in our co-op, could the board or individual directors be liable for any sickness or loss of life? What legal obligation do we have to ensure that the co-op and its members follow the guidelines issued by public health officials?
Wow, this is a really good one, actually. And bottom line is we don't know. We don't have any precedent, do we? Not like we don't know exactly what's going on here. But first of all, you've got insurance for these kind of things. If somebody ever felt the need to, take you to task or take the co-op to task on this sort of thing, you've got, hopefully you got insurance. I kind of wonder if you've got pandemic coverage for directors and officers liability issues. But if there's no big outbreak of COVID and it happens spontaneously, then I don't know how anyone could find a co-op at fault for that. It'd be very difficult to prove it was due to some sort of negligence. That changes slightly if you are determined to have meetings, like large meetings, or if you're a great big co-op and you have more than 50 people showing up at a meeting and you're determined to go ahead anyway, and the directors decide this is a really good idea, despite what Dr. Bonnie says, we're going to go ahead and do something like that. So that would be, you're starting to cross the line on these things. I've wondered aloud about whether you should be taping off your playgrounds, because that's the parks are doing that. So, what I do is I take your cues from what everyone else is doing, especially what the government's doing. So if government is saying, look, don't congregate, don't have, sports things happening in your complex, don't try to have meetings, things are going to change about mid-May, I understand, with small gatherings, but currently, you got to be wondering if you have enough room to have a directors meeting, if all the directors are going to show up. So the second part of this is, what legal obligation do you have to ensure the co-op members follow the guidelines? I don't think any, because you can't control what people do. We all know that. It's like herding cats, right? I think we're well-behaved people as a society anyway, because I see people behaving properly in grocery stores and all of that. You have to hope people are going to do that in your co-op as well, but some people won't. But as far as a legal obligation goes, as a board, you can't control the actions of others in that regard.
Good.
Anything to add, Jeffrey?
Solid answer.
Great. I mean, the standard of the duty of care, as it's expressed in the Act, is that you'll exercise the care, diligence, and skill that a reasonably prudent person would exercise in a similar situation. So you need to ask yourself, what would a reasonably prudent person do faced with the conditions that we're facing now? So Michelle, question 9.
Just one clarification from the chat room about whether or not the insurance program for directors and officers liability insurance would cover the co-op in this stance.
That I don't know. Haven't looked at it. I know that there's, I've been doing some commercial tenancy work, and everyone's talking about what's called force majeure clauses, which are the acts of God clauses. And I don't know, like insurance policies often have that sort of thing too. That's a question for cooperators, I guess, who's like does most of the insurance stuff. But I find that the type of I don't know. I'd have to. That's a question we should look at. Whether there'd be any exclusions for essentially the act of God, which is pandemic issues. I would probably say no, because I don't think anyone thought this was going to happen. Which is for the future, right? When we renew, we should be looking at our insurers and saying, I wonder if they're going to throw in like pandemic clauses.
Yeah, especially for directors and officers, you'd think it wouldn't be a problem, as opposed to some other damage to the co-op. But Grant's right. You got to check the policy.
All right. Let's move on to question 9. And we've been getting this question quite a bit, or variations on it. Our co-op rules provide that housing charges must be approved by members at a meeting called for that purpose. In these extraordinary circumstances, does the board have the authority to reduce or waive the housing charges already approved by the members?
Okay, my turn. You may have policies on this, but let's assume for the moment you don't. And it would be unusual that a policy would contradict the section of the occupancy agreement 404 that talks about members approving housing charges. So the answer in that context is no. The board has no authority to actually just outright reduce the housing charge. What the board has the authority to do is postpone it, delay it, allow someone to enter into a repayment agreement. And the board should do so when dealing with someone who's a good member who's facing these recent events. Your obligation is act in the best interest of the co-op, which includes keeping good members who want to work with you in times of trouble. And so that's what you do. You would postpone an amount for a future time. If there's something that would mean that the member would actually get an absolute forgiveness of it, that's potential, because after all, the board still has those executive functions. But that should be looked at down the road. But all of this they're not reduction of the housing charges. They are, in the circumstances of any given member, giving that member the due time they need to bring it back to normal.
Anything else, Grant?
Nope, I agree with that.
It's good, yeah. Our advice to co-ops has been, don't respond to a problem that you think you might have, respond to a problem that you know you do have. And you only get that knowledge by talking to your members, reaching out to them, finding out if housing charge payment is going to be a problem. So, Michelle, let's move on to question 10. We're doing pretty well for time, so not too worried about our agenda. So we're going to move on to a bigger, broader question around policies, not just the narrow question of housing charges. Does the current situation give boards any room to make exceptions to co-op policies that have been approved by members? So this questioner provides an example. Our co-op allows sublets for up to 2 years. Could the board allow a sublet to last longer if the members are unable to return during the pandemic? And we might even want to take this out a bit broader and speak to the question of policy administration generally. So who's starting on this one?
I guess that's me. So I've been of the view that the board of directors have the authority to run the business of the co-op. It's in the Co-op Act, it's in the rules. So the board does have discretion to do what they want with the policies. They might have been voted on by the members. They need to be voted on by the members. But the board can be flexible about these things. And so when you're looking at a situation where, let's just take the sublet one for instance. Let's say, for instance, a sublet ends, you're now going to put somebody out during a pandemic and the unit's empty because someone's stuck in like New Zealand or something like that and can't get back. Is that good for the co-op? Is that good for business? What's the best interest of the co-op right now? Probably to keep somebody housed, anybody, as a sublet who's paying money to the co-op. So that's an example of the board of directors being in charge of running the business and making a good business decision in the best interest of the housing co-op. So, bottom line, it says, yeah, I think the directors can be flexible about those things.
Jeffrey?
Just quickly, the occupancy agreement, if that's where the source is, the occupancy agreement 1301 says, except with the prior written consent of the directors, you can't sublet. I mean, I think that gives you the authority there as well for the board to approve or not approve anything, but it's also depending on the co-op had policies to this effect as well. But yeah, Grant's answer is right. The whole point to the board having the authority to run the business in a manner shouldn't be hampered by the policies.
Thank you. So here comes another policy question, question number 11. A burning question in some co-ops who have overhousing policies or occupancy guidelines that require people to relocate within a co-op as their household size changes. So can the board enforce an overhousing policy and require such an internal move during a pandemic?
I think it's me. It's subject to the obvious reality of not actually forcing the move. Let's step back. Can the board begin the process of advising the member that when it's safe to do so, that they will be expected to move? And in the meantime, can the board make decisions in keeping with the policy that are consistent with what you did before the pandemic? The answer is yes. The pandemic doesn't mean it's not business as usual. It simply means there's certain restrictions. And so if someone's overhoused, then there's usually a protocol of warning them they need to take one or the second or maybe the third one. If this is now the third one, the board can proceed. And if the member refuses, the board could proceed with the termination for that matter. If the member says, I'll do it, but when it's safe to move, then that would be the compromise. So all of this is subject to the fact that you still are entitled to run your co-op, keeping in mind you can't put anyone in harm's way as a result of this pandemic.
Grant?
Yeah, I think it's you can enforce the policy, but should you enforce the policy? Because the public policy, because this is without precedent, of course, but public policy is to keep people in their homes for the reason of not spreading COVID. So when you ask people to move around from unit to unit, you're exposing that family to a wider bubble of people, which Dr. Bonnie says is not a good idea, at least not yet. Maybe in a week or two it'll be fine. So I don't think it's a good idea. Then we'll go back to that question number 8, which was, could you be liable? Which we don't know the answer to, but that would be a fact pattern that would fit into somebody who was upset about this, who got COVID after they moved, to say this is all your fault. So another thing that you might be protecting your co-op's position by sort of maintaining status quo until the emergency's over.
Yeah, but again, I do say, let me jump back in. I still say though that you can get the wheels in process if there is currently a basis for doing that. So if it is time to move and this member's not in compliance, you can get that process going, subject to all of what you just said about the practical reality. But the pandemic doesn't mean the rules go out the window. It means they're modified as the circumstances fit.
Yeah, so no, I agree too. You can get things going in motion, because right now I felt in the last 30 days or 60 days we've been in inertia, especially with a lot of the things happening with my clients who are sort of waiting. But that it's going to be turned on again. It's going to happen. Maybe it's going to start in 2 weeks, and by July we might be at our new normal. I'm using air quotes, but everyone can see the air quotes. So whatever that might be. And so my clients are starting to say, okay, well, can we start the process? And so what you're saying, Jeffrey, is, and I agree, is like, well, get it going. Otherwise, you're going to be behind. You'll be a couple of weeks behind if you wait a month or so. But get it set up for that move. But don't make them move. I wouldn't do it today. If they're supposed to move today, I'd say, no, don't do it today. Just wait until the authorities say it's safe.
Yep.
I was just waiting for a paramedic or a fire truck to make its way by my place. I didn't want you to think that was my ride. So that's question 11. Let's take a run at question 12. So this will be interesting. And there have been several references made to Dr. Bonnie Henry so far. So let's talk about physical distancing. Does the board have any authority to enforce physical distancing among members? And more to the point, are members who host parties in breach of the good neighbor provision in the occupancy agreement, or in fact, is that conduct detrimental to the co-op? And for those of you who aren't familiar with that reference, conduct detrimental to the co-op is one of the 3 grounds in the Co-op Act and your rules for membership termination. So what about this physical distancing and the board's authority to consider it to be a breach of a member's obligations?
I don't think so. The board doesn't have the authority to enforce physical distancing. That's public health policy. They shouldn't be doing it, but you can't, like I said, you can't really control people and what they're going to do. If they're hosting parties, I mean, that's just irresponsible. You might call the police. They might be interested if there's a party and the people are packed in the backyard or something like that. They might be interested in breaking it up and saying, look, this is not a good idea. Is it conduct detrimental? I think certain behaviors would be conduct detrimental. Like I've had to deal with a case where a fellow who said that he was in isolation because he'd been exposed but not diagnosed to COVID. And people knew that. And then he decided he was going to come up very close to contractors who he didn't like what they were doing around his unit, and they knew that he was that way. And then he also approached some directors rather closely, and they knew as well. And so I've said that's, can potentially be conduct detrimental, because it's the definition is, it's kind of without definition. It's whatever the co-op thinks is conduct detrimental, and the courts don't traditionally wade into that. It has to be some sort of facts to support it. But it's almost like as if someone had come up to you and given you a physical push. This person has got this potentially has got this sickness, and the closer he gets to you, the chances are that you might get it. And that is almost a threatening act, almost. And this fellow is kind of using it as a blunt instrument of threat. And that, I think, would be enough to at least embark or consider going on a conduct detrimental termination against the person.
Jeffrey?
I agree. Just my only comment would be, in totally in keeping with that, is if there's 2 or 3 people at the other end of the co-op congregating contrary to Dr. Bonnie's order, you know, you are required by law, and you should be socially distancing yourself, and you should assume, in a sense, that everyone in the co-op has it. That's why the point is we are all treating this as if we need to distance ourselves from everyone. So in some senses, if it's a small group down at the other end of the co-op, you know, how does that affect you, and how does that affect the co-op? Because you're going to protect yourself anyway. So, you know, I mean, it's important that we follow these, but I think unless it's something egregious, I'm not sure why the co-op would take a role in this.
All right, Michelle, I think you have a poll for us. On the topic of physical distancing.
I'm going to close it in 3 seconds. So 71% of everybody voted. So it seems that that tip is really working for everybody. Thanks for that.
Oh,
Nice.
nice. Yeah,
Okay,
that's great.
well, so no problems. No problem with the people who are already properly distanced by being on a virtual webinar, right?
Yeah.
So we have now we have a series of questions, and I point this out so that we can. I'll encourage the panel to be a little briefer in response to these questions, because these are more general and don't have a specific connection to the COVID-19 issue. But let's have a look at
Okay.
question 13, which I know has come up on many occasions in our earlier workshops. So this co-op has principal and associate members, so our rules allow associate memberships. What recourse do potential associate members have if a board decides not to approve any applications? I assume for associate memberships. Can associate membership applications be refused for any reason?
Okay, I think it's over to me. The law allows a wide discretion, obviously, to whether the board will approve any membership application, associate or not, and you can't make that decision contrary to the Human Rights Code based on race, religion, sexual orientation, etc. And you have to make the decision in good faith and in the best interests of the co-op. But other than those very narrow window, the board has the absolute discretion. And outside of breaching that kind of thing, there's no recourse because the board has that discretion. And so an associate membership application can be refused for any reason, any valid reason, and nor does the board have to disclose that. And the whole point to this is you can't have boards being handcuffed by having to explain their decisions on membership applications. So I don't see any difference with associate memberships or principal memberships. Maybe you have a policy on there should be more associate members who are spouses or something, but apart from that kind of policy, no, there's no recourse to the board.
Grant?
I agree.
All right, you guys are too agreeable. I just saw a question in the chat room asking if are any of you, or any of our panelists tonight, or has anyone on the call bought a pair of Dr. Bonnie's Fluvogs? And I guess the info we have there is that they're sold out. So good luck if you're still looking for them.
I just want to report this because I just got an email that the interpreter for Dr. Bonnie has got T-shirts out right now. They're quite fabulous. So just in case, it's on Vancouver's Awesome. There you go.
That'll be our next round of door prizes. So, Michelle, question 14. So this is an interesting one. If a member is moved out, but is paid up until the end of the month, so I'm assuming that the member has moved out before the end of the month, but is fully paid up, Can the co-op gain access to the unit to do necessary repairs?
The answer to that is no, because by having paid up to the end of the month, they are entitled to possession to the end of the month, whether they're there or not. Of course, you can agree, like you can get their, if they let you in or agree to let you in, that's allowable. But the basic answer is no.
All right. What do we have in question 15?
Just one clarification question from a member about serving the 24-hour notice of entry. Would it be okay to leave the notice on the door, on the map?
Oh, today. All right. Well, what's that say? 24-hour entry. Do you know, Jeffrey?
Well, it depends on what the rules say about that. Whether that what does the occupancy agreement section say?
It's 20.
It'll be in the it'll be in the notice provision of the rules.
Yeah.
Okay. So it talks about, the model rule talks about delivered personally, placed in the mailbox. Doesn't talk about posting it to the door, but talks about placing it through the door.
It doesn't. It says on the unit though, doesn't it? Or...
Does it say on place through? Oh, affixed to the principal entrance. Affixed. There you go. Yeah. There you go. Yep.
So those are all your rules for service and stuff like that. So you can stick it on the door.
Yep.
So I guess the point of the question of clarification perhaps was, is that service of notice still valid if the person serving the notice knows that the member is no longer resident in the unit?
I see. Okay, I see. I think it is.
Yeah.
Yeah. I mean, too bad, so sad. You should be there. And so, yeah, I think if it's a legitimate reason to go in, and now that you know they're not there, then you're entitled to.
Okay, so serve those notices. Here's 15. The board appointed new directors to fill 2 vacancies, as most rules provide, until the next AGM. Now, those directors were appointed by the board. Can the board remove those directors? This must be buyer's remorse. Can the board remove those directors before the AGM, since they were not elected by the members?
No, the
My
answer
turn.
to that is no. Oh, your turn. Oh,
no,
sorry.
My turn. But we have both had the same answer. No.
Oh.
Once they're directors, they're directors. The only way you remove a director is by a special resolution under 18.11, and that's a special resolution at a general meeting. And the whole point is, once you're made a director, you can't have your fellow directors remove you.
All right. Let's go to question 16. Can a board change its officers? For example, remove a director from the position of treasurer and assign that position to another director?
Yes, they can, but assign is kind of the wrong word. Officer positions are decided by the board of directors, and that's by a majority vote. So typically after every AGM, the new directors get into a huddle and they decide right then as who's going to be what position. So if along the way you don't like the treasurer, or the treasurer's doing that job, or they don't want to do it anymore, the directors themselves can do a majority vote, removing that person as treasurer and then appointing somebody else. That's how you do it.
All right.
Yep.
Let's have a look at question 17. Can a director, here's that assignment issue again, can a director who becomes ill assign a role that they've been given by the board to another director? Or is that a decision for the board to make? At what point should a director resign if they're unable to perform their duties?
Okay, it's over to me. Certainly a director can say to another director, hey, I don't want to do this anymore. Do you want to do it? And then let's get the board to ratify it. So that may be a way to do it. But the point being is, it's only the board that decides that. So again, you may want to make it convenient and get it all set up, but it has to be ratified by the board, full stop. What point should you resign? I mean, it's a tough one. Tom mentioned earlier Section 84 of the Cooperative Association Act. Your duty as a director is to act honestly and in good faith with a view to the best interests of the co-op. and you're required to exercise care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So if you feel you can't fulfill that duty physically or mentally because of whatever issue, then you should resign. But so it's kind of general, but go to 84, and if you can't do your job, you should resign.
Okay. All right, what does question 18 have in store for us? Our co-op does not allow pets. A member has submitted a doctor's letter prescribing a pet for emotional support. Is the co-op obliged to allow it? Is this a human rights issue? Grant, I know this is one of your favorite topics.
Oh, yeah, consumes a vast amount of time at my office, these matters. But yes, it's a human rights issue, and no, you're not obliged to allow it. We have what's called like the ladder of inquiry on these support animals. A doctor's letter is usually, in almost every circumstance, virtually worthless, because doctors will put down on paper whatever their patients ask them to put down on paper and don't usually inquire any further. So for an emotional support animal, what we normally do is say, okay, well, we will ask the member, as the lawyers for the co-op, to speak to their doctor or to a specialist. There's a specialist involved that actually can diagnose somebody and say the pet is good for emotional support. And we'll speak to them and say, why is this necessary? Or do you think it's necessary? Because under the Human Rights Code, you have to accommodate someone's disability. So they first have to have a disability. If the doctor says, well, no, I don't know if they have a disability, I don't know exactly, I haven't tested whether the animal is helpful or not, they just tell me, they report back and they say they feel better. That's not going to cut it. You're going to need something like from a psychologist or someone who can can diagnose a mental disorder or illness that needs to, and this could actually work. So I've had circumstances where I've had qualified practitioners tell me this person must have this animal or they will become suicidal. Okay, that's good enough. Let's make the accommodation. Let's get them in there. And a lot of them just simply say, well, I don't know. They just told me that it feels better. And I often say, okay, well, no, we don't have to allow you to have the animal in. I was talking a little bit earlier about a case that showed up in the Georgia Strait recently. And I think maybe this question might have come from that article. And it was a situation where a young lady had a dog and in a no pets strata corporation, and the big news was, well, she simply got to keep her dog because she said that it made her feel better. So I dug into that a bit and I said, well, that would be really extraordinary and sort of change everything how I see the world. And then I saw that, in fact, the strata corporation just sort of rolled over on it. They didn't bother to defend or anything like that. So it ended up that the complainants in the Human Rights Tribunal didn't bring any evidence at all, like not any sort of third-party expert evidence, or just simply came to the tribunal and said it made us feel better, and that was good enough. And now that's not precedent as far as I'm concerned. That's a particular circumstance, and that's all they had to do was reach that one. But I'm not happy about that particular case, because it looks like it might have lowered the threshold on these types of things. So I'm not going to change the way I do things, but I'm going to be aware of that particular circumstance, that particular case.
All right, thank you. So we have one more question left in this section of the rules. It's a good one. So let's see, question 19. What can a director do if the board regularly oversteps its authority, disregards co-op rules and policies, ignores proper procedures, and fails to exercise due diligence? Could disputes between a director and the co-op board on these kinds of issues be heard by the Civil Resolutions Tribunal? And in the course of airing out that dispute, how much information can a dissenting director disclose to other co-op members? Over to the panel.
Okay, I'll take a shot at it. I'm going to start with a bit of an assumption that these are really just procedural things, that what this director is doing is not, we're not talking about personal, financial, or other information about members that might get disclosed. We're talking about a director who stands up and screams at fellow directors or storms out of meetings. Generally speaking, I don't think that's confidential amongst board members. I think a board member could say, you know, I'm not going to talk about what we talked about at the meeting, but I don't think my fellow director acts appropriately at meetings, and I want to do something about it. And in my view, I think the member could, under Section 151 of the Cooperative Association Act, requisition, so you need 20% of the members, requisition a general meeting at which a special resolution to remove that director would be held, or simply the rest of the board calls that meeting to remove that director. That's the way to deal with it. But I think perhaps this question assumes there's one person who wants this and the others don't. Well, I think that person could requisition a meeting. I don't really think the Civil Resolution Tribunal is the way to go, just because I think that's overkill and it's too much outside the co-op. But you never know, they might take jurisdiction. But I think this is all fair game. I mean, you as a director have to act appropriately, and you can be called out if you don't.
All right. That brings us to the end of the rules and policy section. Michelle, I think you have a final poll for us.
Yes, I do. And I just want to recognize that it's just 5 minutes after 7, and we are recognizing and thanking our frontline staff. I know we don't want to bang pots into the session, but just to recognize that. So I'm just going to launch the poll now.
Okay.
So I'll be closing the poll in 3 seconds. And we have a good voting of 74% of attendees have voted.
Very nice. So the free speech is alive and well in co-ops, at least for the respondents to this poll. And of course, that signals that we're moving on to the section dealing with membership terminations. So perhaps we could have a look at question number 20. So a broader question, has COVID-19 changed the legal environment for membership terminations? Are terminations for reasons other than non-payment automatically on hold? On what grounds can membership be terminated during the crisis?
Okay, so the terminations are not on hold. There's, I think, a bit of crossover thought between residential tenancies, which do have there's a hold on evictions right now for a number of things. Behavior is not one of them as far as evictions go. But terminations right now can proceed on everything you normally terminated people for. The issue is getting over the hurdle of your meetings in the COVID world. So the first issue I had was, how do you have a director's meeting with somebody that you want to have either for non-payment, because you have to have a director's meeting for non-payment, and you have to have a director's meeting for conduct detrimental or breach. So I said, okay, well, if you're going to have a meeting, you can do the e-meeting, but one of the defenses that members can use is a natural justice defense. And I thought that a member could say that they tried to participate on an electronic meeting and, well, their internet bandwidth is too small, or they didn't have the right technology, or they kept cutting out, or they couldn't speak. And that's all natural justice issues, like whether or not you can participate, whether you know the case against you, whether you have a chance to speak. So I thought, well, okay, those are, if you have an e-meeting at the director's level, you can do it. But I was a little bit afraid that, or concerned that the members might bring up natural justice issue. If you had a meeting in person, I think a member who was up for termination could legitimately say, I'm not going to that meeting in person because I'm afraid. And that would be a natural justice issue too. So if they didn't attend and you had to vote anyway, even if you had a great big room for meeting and you're all spread out, they, I think, legitimately could say, well, I'm not going to attend because I'm afraid. I don't want to leave my unit. So even if you get over those hurdles, your next one is if they say you're doing conduct detrimental, the next step, if the member doesn't like it, well, they appeal to your general membership. And so right now we're stuck with having general membership meetings. We can't do that in person right now, unless you're a smaller co-op and you can get the social distancing done in the whatever confines you have as far as meeting rooms go. An e-meeting for conduct detrimental, I think, would be a gong show. I mean, I haven't done one before, but I dread the day that I do. It just sounds to me that there's everything, because they're always so emotional and there's always so, you know, action packed. It's not as dull as going over a budget and voting on that. It's somebody's housing we're talking about. So an e-meeting is possible. I just have a hard time conceiving that would run smoothly. And then if you go to the next step, okay, you terminate them for conduct detrimental or for non-payment, and they won't leave. Well, where are you going to go? Well, to the court. Oh, hey, the courts are closed because of COVID right now. So they're indefinitely closed. I've heard rumors, at least from Victoria, that they were going, the Victoria Courthouse was thinking about taking in-person filings middle of May. I don't know if that's the case. If I had to predict, I would guess, you know, June 1, maybe June 15 latest, to get things going again. So yeah, you can do terminations, but there's these hurdles and they're all like, you know, meeting and the courts are closed. So I've been telling my clients on these ones, like, get ready, because I think you'll be able to safely have your directors meetings in the next 2 weeks, and membership meetings, I'm not sure how that's going to look in the future. But just so you know, I'm organizing a Strata Corporation meeting in a parking garage, an SGM in a parkade. They're all going to move their cars out, and we're having the meeting in the parkade because it's huge, right? But that might be how we're going to have meetings from now on if you have a parkade in your place. So anyway, those are, yes, terminations are, you can carry on as you normally had. You're just going to run into some issues when you try to have your meeting and go to court.
So it sounds like what you're saying is the barriers, to the extent that they exist, aren't as much legal as they are practical.
Yeah, that's basically it.
Okay.
Yeah, and I completely agree with all that. And again, my point earlier was that doesn't mean you don't address things. If there's a need for a notice to go to a member about arrears or whatever, then you proceed with that. You shouldn't shy away from an entire process. You should engage the parts that you can engage.
Okay. Thank you. On to question 21. I think we've dealt with this in some respects, but let's maybe a quick recap. Are members who refuse to maintain physical distancing engaging in conduct detrimental to the co-op?
Okay, and I know we need to move on, Tom, so I'll answer this one quickly. The answer is no, unless they're actually approaching you or others in a threatening way, which compromises that person's safety. The fact that there's 3 or 4 people congregating at the other end of the co-op, and that has no impact on you because you're not going anywhere near them, and it couldn't impact on anyone else, is not conduct detrimental.
That okay, Grant?
Yep, agree. Yep.
All right, let's see question 22. More on terminations. If members won't pay or won't make arrangements to pay their housing charges during the COVID-19 crisis, can their membership be terminated after the crisis is over? When should that process be initiated? And is the co-op obliged to offer them a payment plan?
You can terminate them now. There's nothing preventing you from doing that. You can have your directors meet, or you can give them the reasonable notice to pay, have your directors meeting, terminate them. If they don't like it, they're supposed to go to the Supreme Court, which they can't currently do. If they don't move, then you're going to Supreme Court. So on for non-payment, it's much easier right now. I'd say press ahead. Nothing stopping you from doing that. And then wait until the court's open if that's how it's going to go down. Are you obligated to offer them a payment plan? No, you are not.
All right. What do you have for us under 23, Michelle? What steps are we able to take during this crisis if members consistently default on the terms of housing charge repayment agreements they have signed?
Okay, I'll take this one. Same as you're always entitled to. If these are COVID issues, you may be in those discussions with those people, and that's a good thing. But if they're not COVID issues, then you're entitled to proceed. And as Grant said, it may be that there's no appeal to court yet, and you have to wait for that outcome. But no, business as usual. Absolutely.
All right. Let's have a look at 24. Does the co-op have a right to ask for proof of lost income if a member claims COVID-related hardship as a reason for being in arrears?
I think that it's actually the member that should be making that available voluntarily if they want to convince the co-op that there's some sort of hardship that should be addressed. I think if the co-op is in the position of having to demand income, then perhaps the member isn't as serious as they should be about the issue, because they should be just giving it up and letting you guys know about that. So I think that if you had to think about the checklist of allowing somebody to get a rental or get have a hardship case or access to subsidy wouldn't normally be access to, a checklist should include, well, at least tell us why, like what's happened to your income. Have you been let go? Have you applied for CERB? Have you applied for those sort of things? So it's just a checklist, I think, of evidentiary items you would want to make sure you're doing the right thing and giving them a break on housing charges.
And maybe a related question, a question that we weren't asked, but we've received it quite frequently in the office. In responding to requests for housing charge relief from members who've been hit hard by COVID-19, can the co-op insist as a condition of making those payment arrangements over time that members have made a reasonable effort to access some of the government assistance programs that are available, like the temporary rent supplement program or the emergency relief benefit available from the federal government?
Yeah, I mean, I think it's all fair game. I mean, after all, the accommodation you're giving to members who are hit by this is a two-way street. Everyone has to do their best to get through this, and if the member, despite that, still needs some time and a reduction, then so be it. But this is a two-way street, absolutely.
Yeah. When I've been negotiating repayment plans or payment plans for tenants in the landlord-tenant world, one of the terms is that the tenant represents that they have applied for the rent benefit. I thought about whether I should do like the emergency benefit, but I mean, the emergency benefit is more like for living. It's not really meant for tenancy. And so I've sort of tackled it as saying, well, let's go after the money that is actually for rent, because this is what they're going to get. The landlords get it directly, or the co-op's going to get it directly. So one of the terms is that either the tenant will or has applied for the benefit. And then if they don't, and they could have, then the landlord can renege on the repayment deal. But it also recognizes that some people, even though they've lost their jobs and don't have any money, can't access it somehow. At least, yeah, because there's some instances where people have fallen through the cracks, at least in the landlord world. They won't be able to get the benefit, but yet they're asking for rent reduction.
Okay. So now there are two more questions left in the membership termination section. They aren't really COVID related, but I think if we deal with them quickly, we can probably squeeze them in. So let's see 25. Are members who dump garbage in inappropriate places, so the recycle bins, the laundry room bins, are they engaging in conduct detrimental to the co-op?
Okay, that's me. On a small scale, yes. I mean, it's obviously, this is one where you don't want to give them a detailed.
We lost Jeffrey's sound.
We lost Jeffrey momentarily. He's got a backup plan though.
He does, yeah. No, we can't hear you, Jeffrey.
This is your chance to disagree with Jeffrey, Grant.
Exactly.
Oh, there you go. Oh, too bad.
There we go. Oh,
Okay, now can you?
we almost had him.
Yeah.
Hold on, can you hear me now?
We can.
Yeah.
Okay, sorry, I charged up my earbuds, but apparently not enough. So there we go. So if it echoes a bit, because I'm just using the speakers. Okay, so yeah, the answer is yes. I mean, that's conduct detrimental. It's a breach of the good neighbor provision, and the board should write warnings about that. It's not a particularly material element, but it is in fact. And so yes, move ahead with warnings.
Okay, question 26, the last one on membership termination. Here we go. A member's teen vandalized another member's unit. The Civil Resolutions Tribunal awarded the cost of repairs to the co-op. Amazing. But the offending member refuses to apologize. Does this give the co-op grounds for termination of membership?
Yeah, so when we were looking at this question, I think the thing that struck us as most extraordinary is that they got a judgment of the Civil Resolution Tribunal for this matter, because it's not, shouldn't be, right? It's not, if you knew the law, like as Jeffrey and I do, you know, it's not like a given that the teen would have, or the parents would have to pay for the vandalism of the teen. But for that aside, the member refuses to apologize. Well, the member's not required to apologize for this. Does that give the co-op grounds for termination of membership? As I said before, I mean, membership termination and grounds for it is really what the culture is at the co-op. If you think your members will think that failing to apologize is conduct detrimental, then I suppose that's something you'd want to pursue. The test at the court is natural justice and then some sort of fact to support the termination. I don't know if failing to apologize is a fact that would support determination. It doesn't sound to me like it would be. So if I was asked this, co-op said, oh, should we proceed? And I go, well, you got to take the temperature of your people. Do you think they're going to put them on the street because they failed to apologize? I'd probably say, nah, I'd probably leave it.
All right. That takes us into an entire section on financial questions. So here we are. We know there's a temporary rent supplement program in BC, and we know it involves applications made by members and an application made by the co-op. So what's the board's obligation to report errors or potential fraud in applications that have been submitted to BC Housing under the BC temporary rent supplement program, I'm assuming by members?
Okay, I'll take a shot at this. I mean, it strikes me if part of the assumption here is the member is somehow getting money that they should, by funneling it to someone else or something. It strikes me, doesn't that mean that the co-op is not getting it? Because I would have thought if that's the case, then I mean the co-op certainly can say, well, you have to pay your rent, and if you're getting your friend this money or something else, you know, you're not paying the co-op. We're not getting it. So I mean, that's a simple part there. But if it's simply an observation of it, I mean, I think you still are entitled to. I mean, you don't ever want to be on the wrong side of any of these programs about a failure to report when you knew about it or being complicit. And I mean, the federal government's going to look quite closely at this in a year or two and to make sure people who cheat are caught. So in general, you can't go wrong by reporting fraud.
True. I don't know if the board has an obligation, because the board's not part of the, unless the board's part of the application and they realize that there's a fraud happening. And yeah, I think you ought to say something, but it's kind of like, you know, watching a car accident across the street. You have an obligation to phone the cops right then about it. Well, good citizens do that, right? And if you see a fraud, most people will report a fraud. That might be an individual choice, but I don't think the board itself, like the corporate board, has an obligation to report it.
No, and I agree. And that's why I kind of started with, well, why does anyone care if it doesn't involve the co-op? But again, I don't see any downside if you're aware within the system. But yeah, I mean, you don't technically have an obligation if it's just an observation.
All right, let's move on to question 28. One of our members will not have a job to return to after the pandemic is over. What are the co-op's options if they just can't afford to pay the full housing charge?
Just me?
Yes.
Okay, well, your options are to offer the member subsidy if you have any left. If you don't have any subsidy left, then you're running out of options. you might have to consider asking them to move out or terminating them for non-payment. I don't know what things are going to look like in the future, as far as funding goes, as far as the emergency goes, like how long it's going to last. You might not have to make those hard decisions for a while. It's not going to go back to normal with employment. People aren't just going to, most people, if they've lost their jobs, are not going to immediately return, or maybe they will, I don't know. But big chunk of our population won't. And that's going to have to be maybe a hard question that co-ops are going to have to ask themselves. If you're out of operating agreements, it becomes even a little more thornier. But that's what co-ops are about, aren't they? I mean, they tend to look after each other, and we got ourselves a really crazy situation right now. Those are conversations that you're going to have not just with your board, but maybe your members, and saying, what are we going to do to help our people? If you're out of operating agreement, you might be able to spread it out a bit better than other places can. You've got far more options than stratas or rentals do. Might be the opportunity to become leaders in the housing industry on how you deal with it. So instead of looking at it as a terrifying moment where you have to make difficult choices about people who can't pay their housing charges, it might be a chance to be a leader and see what you can do for your community.
What do we have in question 29? So a bit of a twist on this. Does the co-op have an obligation to allocate subsidy to a member who's on a wait list for subsidy if the monthly subsidy budget is fully committed, even if there's money in the subsidy surplus fund?
Okay, I think that's over to me. I think the answer is no, because of the question speaks for itself. I mean, if the budget is subsidy budget is committed, that means under your policies, or if you've got an operating agreement with the subsidy provider, that you're at that point. So the question really answers itself in the terms of, if the co-op is following its own policies, then, you know, there is no more subsidy available, and most policies don't allow the subsidy surplus fund to be run down just because there's more applications. Most co-ops have a set number of applications. So the question is, are you under an operating agreement? And if not, what are your policies? And as well, the board needs to act fairly and act consistently, so they can't pick and choose, but there's no obligation to receive a subsidy if doing so is contrary to policy, or even if there is no policy, the board still has the discretion to maintain the subsidy surplus fund.
Yeah, this is the strategic conversation that's happening in co-ops now, and we'd encourage co-ops to have a full and open discussion about it. And if your monthly allocation for subsidy purposes is being fully deployed, then there's no other source of income to put toward that goal. Now you do have those subsidy surplus funds. They're meant to be for a rainy day. Some people would argue that the COVID-19 pandemic is the perfect definition of a rainy day, so that issue should be put on the table. But it's not a question of an obligation, but a question of you know, where do you see this fitting into your mission as a co-op, and take your cue from that. Think we can go to 30? We're doing pretty well. Well, this is a question that's not entirely COVID-19 related. It's a question that co-ops face as they come to the end of their operating agreements with CMHC or other levels of government. When that subsidy surplus fund is fully depleted, must the co-op continue to allow members to pay reduced housing charges based on their incomes?
Well, pretty short answer, no. Don't have to. If you don't have any more subsidy left, or if it's fully engaged, I guess. I don't know if depleted means like there's nothing there at all. You're not compelled to have members continue to pay based on income if they reached a certain threshold. If you're out of operating agreement, you're going to have to Like you don't have anybody watching over you anymore. No one's giving you any money. And you're gonna have to decide, as this is like an old conversation we've had, but you have to decide whether your co-op is going to have like a few members down here and then everyone paying up here, or whether you're going to do this. So that's a question that everyone coming out of operating agreement was thinking about, is what are we going to do? Flatten our housing charges, or are we going to try to maintain subsidy for members? But if you don't have any subsidy left, there's nothing to give, and people have to pay the housing charges they have to pay.
Yeah, this is the question that our co-op services team is really helping co-ops answer through a very dedicated planning process, because must you isn't the only question here, right? It's can you and should you? And again, that moves the question from the legal arena into the question of what the co-op's mission is and what its values and are and what its vision is for the community. So I'd encourage co-ops that are asking this question, and it's absolutely a good question to ask, to get in touch with our co-op services team and start that process of opening up the discussion to the entire community and decide what your mission is going forward as a co-op. Does that take us to 31, Michelle?
Yeah, there's just one comment in the chat that some leases do require that some units are offered with rent geared to income. And that's just a comment from our co-op services team.
Yes, that's right. Yeah. All right, I think we're ready to move to the operations and maintenance section. So this is interesting. Can a co-op take steps during the pandemic to restrict non-member vehicle and pedestrian access to the co-op property?
Okay, over to me. Generally speaking, no. I mean, after all, you may have members who want their family to visit them. The answer comes where there is a point where there's so many people coming that they can't socially distance, and it's now a health threat to the members. Yes, at that point, you probably could, but just as a general rule, if letting a few cars come in and those people aren't interfering with your ability to keep safe, I don't believe the board has any right, or the co-op has any right, to prevent me from inviting my family into the co-op, so long as we do all that we're supposed to do.
Yeah, this
Anything
is
else,
one where,
Chris?
yeah, we might actually disagree on this one.
Okay. All right, I knew it. It's only taken 31 questions to find the disagreement.
Yeah. I'm more of the view that they can restrict, and so I'm taking my cue from the landlord-tenant arena. They've got a ministerial order, and part of it that came down said that the landlords can restrict access to common areas to protect tenants, but they can't restrict guests going to the tenants' units. So I thought that was hugely problematic, because if you had like a common area or a green space or something that everyone had to, and you close that off, but everyone had to actually go across that area to get to a unit, how can that be useful? So contradictory provision, but I thought that if the government by ministerial order was going to grant landlords the ability to put in some sort of like draconian restrictions if they wanted to on common areas, like for instance, no more pool, no more weight room, no more common room, no more of gathering in the foyer, all that stuff, no more using common facilities. I thought, well, why can't the co-ops do that? We don't have a ministerial order actually allowing that, but I think the board of directors have the ability to control and maintain common areas, because members don't have rights to common areas. They only have rights to the unit inside there. They don't have actually don't have a right to their gardens or anything outside their buildings. And I think the board can do something about that if they felt like it temporarily.
Okay, well, we will disagree on that because I do think it needs to be measured in what's happening. So if the parking lot's empty and I can't have my mother come and visit me that night, and she's not going to be anywhere near anyone, I think that cannot be applied as a rule. So it may be a matter of degree.
Yeah.
Well, it's going to be difficult for us to settle this.
Yeah, well, my next thing was like, how do you create a enforceable document on that? And you can dictate it as the board of directors, but then where's the teeth? The landlords have got the ministerial order and the co-ops don't.
Right.
There you go. See, if we were at the education conference now, you could be tossing glasses of water on each other. But here we are online. You know what can we do?
Just do this to him.
Yeah. Very nice. Michelle, what's question 32? The co-op office is currently closed. I should hope so. But the manager is picking up essential documents periodically, like housing charge payments, subsidy applications. The board's trying to make things a bit easier. Can the board authorize a director to access the co-op mailbox to sort these documents in advance of the manager's visit? Does this create privacy concerns?
Is it my turn?
Yeah.
Okay. I thought, why? My first question was why? Because it strikes me the manager is probably used to organizing documents anyway, but why would you have to organize them in advance of the manager's visit? So I thought, okay, why? Is this an excuse to look at stuff that they don't ordinarily look at? Then I thought, well, it doesn't really matter anyway, because there isn't, and I've seen this before, like the co-ops have tended to put up like these walls between management and the directors. I didn't quite understand that, because directors have got all of these obligations under the Cooperative Association Act, including privacy obligations, the very same as managers do. So I never saw a problem in giving directors access to these particular things. So my first thing is like, why? What's changed that it's now necessary for someone to organize for the manager, and what's behind that? And then secondly, if there's nothing behind it, then I don't see a problem with privacy issues.
Okay.
Yeah.
Okay with that, Jeffrey?
Yes.
Okay, they've made up their friends again.
For now.
Let's see question 33. Should the co-op take steps to reduce non-essential expenses in anticipation of lost revenue from non-payment of housing charges or increased pricing due to supply-demand issues?
Yeah, I mean, look, the question certainly is a board thinking through these things. I mean, you have a budget, and so in part, it may mean you're not going to spend money on a budget, but you're entitled to do that. You have the authority to do that, and you have the authority to manage the expenditures in anticipation of revenue. So, I mean, I'm not sure it's that significant at the moment, if it's of a burden for housing co-ops right now, the lost revenue, but if it is, it's good practice, and the board absolutely has the authority to manage the financial affairs of the co-op.
Okay. Good enough, Grant?
Yeah, you bet.
All right, let's have a look at 34. Oh, why? CHFBC, why are you suggesting that units be vacant for 48 hours before carrying out repairs or inspections? Are there different guidelines for routine repairs, emergency repairs, and move-in, move-out inspections?
So my first response or first thought when I read this was, it's not a legal question. It doesn't have anything to do with the law, except for what underlies it, which might be worker safety. So if I was an employer, and I am, I'm concerned about the safety of my people, and I don't want to put them in situations where I think they might be compromised. And so there's all sorts of information out there about how long COVID will last on a surface. I think it loves plastic the best. Like it could last there for like 5 days or something crazy like that. Paper, not so much. So, but there's so many differing surfaces in a co-op. There's lots of smooth surfaces that could live on. I would, as a careful employer, would want to make sure that I got to the maximum range of hours before I let my people in there, because my primarily concern is worker safety. Different situation if there's an emergency, if something breaks and something has to be done immediately. Most emergency services guys are equipped for that. They'll have the proper PPE equipment to get it done. But I don't know. I just I wouldn't expect for ordinary repairs in this environment for people to simply just rush in and not consider the lifespan of COVID.
Michelle, do you want to add something to this? Nope, we can't hear you.
I muted myself.
There you go.
Yeah, I mean, I echo what Grant is saying, that this is really about workplace health and safety, and that's what we're using as best practices for our own co-host staff as well. And I think the basis of this, I recall us saying 72 hours or more, actually, not 48. But it was coming down to how long the COVID virus is still dangerous on different surfaces, whether it's plastic, paper, carpet, or whatever. So in case of emergencies like that, what we're doing is conducting a risk assessment. There's all kinds of things if it's an urgent matter. Sometimes somebody may have to take a picture of the unit or do a FaceTime, or to see what the condition of the unit is. But as long as possible before going in is the safe approach, is what we're using for our team anyway.
Okay. And everyone, everyone should take their own counsel, I guess, on assessing and mitigating risk. Emergencies are quite a different matter. Emergencies are threats to health and safety or the structural integrity of the co-op, and they have to be dealt with right away using the highest standards of safety and with all necessary precautions. But routine repairs, move in, move out inspections, I would say we need to acknowledge that it can't be business as usual, and there need to be steps taken to both protect the co-op and protect volunteers and workers who may be called on to perform those functions. So it is a bit of a balancing act, but if you're going to err, the approach that CHFBC has taken in both its service provision and its advice to members is err on the side of caution, err on the side of safety, and you can't go wrong. Anything to add, Jeffrey or Grant? All right, let's talk about access to homes. What are the board's options if a member refuses to allow access to a unit for routine maintenance while COVID-19 restrictions are still in place? What if the problem is an emergency? Just a bit of a different take on the same question, really.
Right, and largely it has been answered. I mean, look, if it's routine maintenance, you absolutely should not be doing any of it if the member doesn't want it to occur. And in fact, if your own employee or contractor doesn't want it to occur. I mean, these are different times. And if the word routine means it can wait. And so it should not be an issue. It should not be, you shouldn't even warn the member. It's not even a termination issue at all. And so there's a spectrum. It goes from there to the emergency. So in the case of an emergency, yes, the member has to allow access, and the member should then, and the contractor and the board should think of a way in which that can be done safely. But an emergency is by definition that. So it's a spectrum, but anything routine at the moment should just be parked right now. Absolutely.
Okay. Is that okay, Grant?
Yeah, I agree. Yeah, I agree.
Okay. Let's look at 36. I think one of my favorite questions. A member wants to buy a large trampoline to set up in the co-op's common area for children to use during the pandemic period. What are the issues we should be considering in response to this request?
Trampolines, you're just asking for it. I mean, pandemic or not, forget it. No trampoline. My kids asked me for trampoline for ages. Forget it. No, you're not getting a trampoline. No, they're death traps as far as I'm concerned. I mean, I don't know how many of my friends broke something. I didn't break anything, but trampolines, I'd say, well, generally no, I wouldn't want a trampoline on common area for the co-op. There's just too much stuff with trampolines. And then secondly, during a pandemic, the kids are going to be all over it. They're bouncing up and down. They're touching everything. You can't help it. Like, how do you keep that clean? How do you disinfect something like that? Well, you don't. So, number one, I don't like trampolines. As far as legal liability goes, they're huge. And then secondly, you couldn't possibly even use it during the pandemic. First thing you do if it was there before the pandemic is cover it in yellow tape and say, don't use it.
Yeah.
Do you feel differently about trampolines, Jeffrey?
I don't feel. The lawyers in America make tons of money suing about step ladders and trampolines. If you go to Home Depot and look at an aluminum step ladder, oh, hold it, you can't see it. It's covered in warning stickers. And same with trampolines. So I'm sure the person who asked the question will be disappointed, but it's just not worth it. And it may even be an insurance issue, because insurance coverage for the co-op would cover playgrounds, but someone, a private member sticking a trampoline in common area, that might not be covered by insurance. So the answer is, for all those reasons, absolutely no. And it's no, not from a subjective point of view, it's no from a lawyer's point of view. It's for all the reasons Grant said and me, it's not worth it. It's just not worth it.
All right, so we're going to bounce around from this topic to the next question on the list, which would be number 37. And now we're into the we're in the home stretch here, folks. These are the miscellaneous questions that didn't fit neatly into the other categories. So a member's washing machine hose broke, and the unit suffered water damage. Can the co-op recover its insurance deductible from the member? Firstly, if there's no policy authorizing it to do so, or secondly, if a policy was approved later or after the fact and then applied retroactively. Can the co-op rely on its lien on member shares for payment of the amount claimed?
I think that's you, Grant.
Is it me? Okay.
Yeah.
You've gone from trampolines to washing machines.
Or maybe
Okay.
it is me now. No, I
Okay.
guess I just rattled off. Okay, you can jump in anyways, Grant. We got time.
Okay.
It's in 11.02 of the occupancy agreement. The member is to keep insurance in place on member supplied fixtures, and I think we'll assume here that this is a washing machine that the member installed. And if you don't do that, and the board under 11.03, if you don't do that, and therefore you haven't got insurance coverage for this event, and therefore the board fixes the board's own insurance, I'm sorry, the co-op's own insurance company fixes it, the board can then assess you for the applicable deductible. So yeah, the answer is this is something the members need to be aware of. I always think though, you got to make sure it's something the members should be responsible for. And so if there's a leak in the co-op's plumbing system in the wall, well, that's not the member's fault. So this question kind of assumes that this is the member's fault, and there's often a dispute about whether something is the member's fault and is something the member should have insured for. But this one, it is. As far as the retroactively applying it, a policy approved and retroactively applying it, no, that's not a good idea. You shouldn't. Some policies can be retroactive, but not monetary ones where you're trying to get at someone through a policy on a retroactive basis. So no, I don't suggest it. Retroactive application of policies is very difficult at law, and generally you don't want to go there. But if it is an amount that you clearly are entitled to, yes, you can have, you can take it from the shares. That will be covered by the lien. But again, you got to be very careful as a board that the levy that you're assessing for this deductible is because it's clear that this was an event that was the member's fault, or the member ought to have insured for it. And you can't just as a board say something bad happened in the unit, therefore we'll cover it on our policy and you'll pay the deductible. You have to do the analysis.
All right, anything to add, Grant?
No, that's right.
All right. On to question 38. So this is a question we're getting in the office with more frequency lately. We've received our Federal Community Housing Initiative Phase 2, or the elegantly coined FCHI2 agreement. Was it reviewed by CHFBC's lawyers? Should co-ops have their lawyers review it prior to signing?
Okay, I've never seen it. I know Jeffrey hasn't seen it either because we.
No, I haven't. No.
So no, we haven't looked at it. Should co-ops have their lawyers review it prior to signing? Yes. As it should be with most contracts or anything else you're faced with. It's always worth it to have your lawyer have a look at it.
Yeah. So this is a good example of where we have different jobs, right? I mean, the FCHI2 agreements are very, very new. They're meant to to extend the funding provided to Section 95 co-ops after their operating agreement extensions end under the first phase of the program. But they don't even begin until September of 2020. So the agreements that co-ops are receiving now are meant to take effect on September 1st, 2020, and they run to March 31, 2028. I will say that, I think CHFBC's job is not to express a legal opinion. We're not qualified to do that. We wouldn't try. Our job is to say to members whether we think the agreement is an improvement on the agreement that it's meant to replace, which is the Section 95 operating agreement that provides the subsidy pool for income tested members. And I will say that thanks in large measure to the efforts made by the Agency for Co-op Housing and CHF Canada, the agreement is a dramatic improvement on earlier drafts that we saw, and actually an improvement over the initial terms of subsidy delivery under the Section 95 program. So I don't have any hesitation in saying to a co-op who has received a copy of that agreement, this is a much better arrangement for subsidy administration after your initial program extension expires. But that's not a legal opinion. I'm not qualified to advise you as to whether it's a legally sound document or whether there are legal problems buried in the text. I'm just qualified to tell you whether it's a good deal based on the subsidy that's being offered. So we all have a role to play in this, and I would encourage you to, when you have any legal agreement in front of you and you have questions about whether to sign it or not, you should be consulting your lawyer before you do anything else. Anything else we need to deal with on this one?
Nope.
All right. So question 39 of 39, and it's 7:52. Could we call this a photo finish?
Wow, awesome.
Maybe not, right? So I know this is a popular topic. It's come up in past Ask the Lawyers sessions at our education conference. Can the co-op install fake security cameras? Is that a good idea?
It's your turn. You can answer. You did the last one. Hello.
Okay, well, I'm sure you'll comment on it too. Yeah, and the case where that occurred and the a member feeling that she was more secure than she actually was, then ventured into an area where the fake security cameras were installed because of a false sense of security, was assaulted, and then sued the organization for inducing her to have that false sense of security. So that's the problem, is that you are potentially walking into that situation. Otherwise, yeah, why not? But the problem is it creates a false expectation, and so as a result, no, you should not do it.
Yeah, the privacy commissioner says no as well. They said don't install fake security cameras.
There you go.
Okay.
Not a good idea. So, Michelle, this takes us to 7:54. What would you like to do with the 6 minutes we have remaining in our time together?
I would like to circle back to a couple of clarification points brought up in the chat. There's 3 areas. The first one is an apparent difference of opinion between CHFBC and the lawyers with respect to the consent resolution. I don't think that's the case, but I think we need to clarify it just a little bit. The lawyers have said that consent by email, where each director signs the resolution, is what should be in place. And that's what CHFBC is saying. I think we just added that in light of when you're returning those emails, you may have 7 different documents with 7 different, with one signature on each. That counterpart portion. Tom, did you want to explain that a little bit more?
Yeah, I think I know where this is coming from. I think it boils down to a more, I think I hold a more conventional view of what it means to consent to a resolution. And in my experience, it involves resolutions that have signatures attached to them. So whether that, whether you have all 7 signatures on one copy of the resolution or an individual signature on 7 copies, that's all well and good. The question sometimes arises whether responding by email saying I consent to a resolution counts in the same way as having a signature on that resolution. And on that, I defer to our panel. I just would want to be sure that that all of the potential for fraud or misrepresentation in presenting those emails after the fact was eliminated, and that you could actually count on that consent having been given. For me, a signature is just more reliable. They both might have equal legal merit, and again, on that I defer to the panel.
And your answer is correct. They do actually have equal legal merit, but if your answer yes to a consent resolution is buried halfway through an email, it could get missed. It could get misinterpreted. You may say after, well, I didn't consent. You misread my email. So your point about having a signed even by counterpart resolution eliminates that. So it absolutely is best practice. But nevertheless, if your emails are very clear and you can compile that, and probably at the next meeting, you don't have to ratify it. It's already a resolution, but you may want to make a note, maybe in the minutes, that previously there was such a resolution passed. So it's a matter of practice. I find emails to be very difficult to trace, to use for simple legal agreements where there isn't an agreement in writing, because they can be vague. So it's all a matter of practicality, but strictly speaking, 7 out of 7 directors saying yes by email is a consent resolution.
Okay with you, Grant? Okay.
Yeah.
And circling back to the issue of the pet that was with respect to the human rights issue, would it be okay to ask for proof of that disability?
Yeah, that's part of the process. Human Rights Tribunal recognizes, and actually it's like a reverse onus at the Human Rights Tribunal, which doesn't seem intuitively fair when I describe it to my clients. It's like someone says, well, I have this disability, I need accommodation. And you would fully expect that the person would then say, oh, and here's all my material. That's not how it works. It's like when the person says that, it's really now up to the co-op to undertake the investigation. So I'm used to getting authorizations from members to speak with their doctors, and the tribunals recognize that this is part of the process. You got to figure out what's the disability, what's the accommodation that is required, and then decide if you can actually accommodate that to a point of undue hardship. That's the test, and you can't do that in a vacuum or in a void, and you're not expected to. And often members will want you to do that. They'll want you to do it in a vacuum. They won't want to give up the information.
All right. Do we have one more, Michelle? We're closing in on our time.
We have 2 more. I'm struggling as to which one to bring it to. Who has access to the footage for security cameras?
Well, there's a whole.
Yeah, there's.
Yeah.
Oh, you go ahead, Grant. You know it.
Well, there's like lots of information about that on the OPIC website, the Officer of Privacy Commissioner. They've got a lot of great resources that that will do way better than me trying to explain about who has access and who can have access. Lots of different rules there about video surveillance. It's a big deal for them. They've got some strong opinions at OPIC about video surveillance.
Yeah, it's all about privacy. So they have very strict limits on who gets it, when, how long you can keep it, all that.
And the last one is, I'm not quite sure what he's asking. He's asking whether or not what is the process for appointing a director. But it's not clear to me if it was if the co-op has gone through the process of an election, and then there's a vacancy to fill for the director, and then there's an appointment. So that's why I'm kind of not sure how to bring that question in. But he did ask it 3 times.
I saw that question. So it reads, are you saying that the board wants to bypass elections and appoint directors instead? The question that was raised earlier was around the appointments made by directors to fill vacancies that arise. So if you have a casual vacancy on the board, director moves out of the co-op or resigns, that creates what's called a casual vacancy. And the model rules, if the co-op has adopted those, say that the directors have a choice. When a casual vacancy arises, they can either continue to operate with one fewer director, or they can take it to the next members meeting for an election, or they can make an appointment of a qualified member to fill that vacancy. And that appointment is good until usually for the balance of the term that was to be served by the director who vacated. So it's not an attempt to avoid elections. It's just it's a power the board has in response to a casual vacancy among the directors. Is that fair enough?
Yep.
Yeah,
right.
and then that would just be a resolution at a meeting of the board of directors, correct?
That's right, but it has to be a qualified member, someone who qualifies under the rules to serve as a director of the co-op.
Okay, I think that's it.
I think that takes us to our next slide, which is when I get to say thank you very much to Grant and to Jeffrey for offering us their wisdom, sharing their time with us, and very much appreciate the contributions that you're making to the co-op housing sector here in BC, and looking forward to next time, whether it be online or in person.
And should we go over this joke?
What joke? I did.
Yeah.
Is it on your slide there?
Oh, yeah.
It is. It is. That's just for you.
I've used it before.
Over to you,
Okay.
Michelle, to wrap us up.
Okay, thanks. Well, we hope you enjoyed this session. It was very lively debate, lots of questions. We will be sending you a survey that comes out automatically right after this. And also we want to know what other kind of co-op topics or issues you'd like to learn more about. Our next online event is on May 27th, which is disputes under the CRT. And also there is a session being held by our Housing Central part of BC Nonprofit Housing Association called Living in Isolation in the COVID Pandemic. That might be interest to some co-op members, and that's being held on May 11th. And you can find out information on their website, bcnpha.ca. And that's everything else. Thank you, everybody.
Very good. Thank you, everyone.
Thanks very much.
Thank you. See you next time. Bye-bye.
Bye.